An affidavit has appeared in public from the United States Department of Justice, but inside of that affidavit, well, a tremendous number of redactions. So many things are blacked out, you're incapable of finding out what the basis for this raid on Trump's home truly was. The government does claim that there were at least 184 documents bearing classification markings inside a trove of 15 boxes that Donald Trump had voluntarily arranged to give to the National Archives. And they suggested that there must be many more at Mar-a-Lago before a magistrate signed off on a raid by the United States Department of Justice on Mar-a-Lago earlier this month. A lot more questions than answers, unfortunately, but I'm going to put some of these questions to our next guest. He's the founder and president of the Article 3 Project and a former chief counsel for nominations to Senate Judiciary Chairman Chuck Grassley. Mike Davis is on the phone with us. Mike, good afternoon to you.
Thank you for having me.
What do you make of this document released today? Does it clarify anything for you?
It clarifies that this home raid on a former president, President Trump, ordered by Attorney General Merrick Garland after President Biden paved the way with his waiver of President Trump's executive privilege, was an unnecessary, unprecedented, and unlawful home raid. And it was unlawful because the President of the United States has the absolute constitutional power to declassify any record he wants for any reason he wants, and he doesn't have to get any bureaucrat's permission at the National Archives or the Department of Justice or anywhere else to do this. And that's confirmed by a 1988 Supreme Court case, Department of the Navy versus Egan. The Espionage Act, any other statute dealing with classified records, any regulation, any bureaucratic hoop, any permission sought, that applies to everyone else on the planet except for the President of the United States or anyone authorized by the President of the United States. The President has separate constitutional power because the classification power comes from the President and not from some librarian at the archives. That's point number one. Point number two, the President has the sole statutory power to make personal any presidential record he wants. So under the Presidential Records Act, if the president determines something is personal instead of a presidential record, it's his, and it goes to him. If it's a presidential record, it goes to the archives. They categorize it, catalog it, and then they send it back to the former president's library. And so that's what this dispute is. This is a dispute with librarians at the National Archives who think that books are overdue, and they're not. And so instead of getting this resolved through a civil lawsuit or notifying Congress or a subpoena, the Biden Justice Department cooked up these non-crimes non-crimes of espionage, non-crime of obstruction or theft of government property, and this non-crime of obstruction of justice for obstructing the investigations into these non-crimes, and went to this biased magistrate judge in West Palm Beach, Bruce Reinhart, who just recused from President Trump's civil lawsuit versus Hillary Clinton on June 22nd, 8 weeks ago, because he had this 2017 Facebook post trashing President Trump. So what changed in that 6-week period when this biased judge colluded with the Biden Justice Department to authorize this unprecedented, unnecessary, and unlawful home raid on a former president for documents they were not entitled to go raid, right? And now they're trying to cover their tracks. You see with these redactions, this same biased judge has the same incentive as this Biden Justice Department and this corrupt counter-espionage unit at the FBI to cover their tracks here. And that's what they're doing. They know full well that the reason they went in there is to get the Crossfire Hurricane records, the Russian collusion records that President Trump declassified no later than January 19th, 2021, the day before he left office, as evidenced by his declassification number. That's what this is about. He has damning records on Hillary, Obama, Biden, the FBI, the intel community, and they wanted to get those records back.
So it's your understanding that the president can make any document we might consider a government document his personally? So, for instance, one of the reports was that there were text messages between Peter Strzok and Lisa Page that have not yet been made public. It's possible for the president to say, these are now my personal documents?
Yes. So before the Presidential Records Act was passed in the 1970s and made applicable to presidents starting whoever won in 1980. It was Reagan was the guy who won, obviously. But what happened was these presidential records belonged to the president. So when he left office, he owned the records. He took them with him. And Congress changed that after Nixon. And now there is a dance between the president, who thinks every record is a personal record, like Trump's love notes with the North Korean dictator, versus, the bureaucrats at the archives who think when a president sneezes into a Kleenex, that's a presidential record that should go to the archives. And that is a natural tug of war that happens between every president since the Presidential Records Act was passed. Remember, the Clintons left the White House by stealing $190,000 worth of furniture and rugs and flatware and everything else that they can get their hands on to take back to their trailer in Arkansas. And there was no FBI raid, no FBI investigation, nothing. Hillary Clinton, who was not president and never will be president, had her illegal home server as Secretary of State to, cover her tracks. It was hacked by foreign governments. We know it was. There was no FBI raid, no FBI investigation. This is a political hit on President Trump, and it's part of a pattern of the Obama, Biden, Hillary regimes weaponizing, politicizing the FBI, the intel community to get Trump, and they've done it since Russian collusion. They spied on him when he was a presidential candidate. They spied on him when he was the president. This is just further. This is part of that corrupt campaign by the leadership of the FBI and this corrupt intel, this corrupt counter-espionage unit at the FBI and the intel community.
Yeah, and in Hillary's case, I love the left is Trump made such a big deal about her, and boy, that's a completely different case, isn't it? Because Hillary Clinton, Secretary of State, she didn't have any such declassification authority. She had no right whatsoever to be handling the documents the way she was on this private server. It is actually a completely different scenario, no?
Well, yeah, and remember, the Congress and the Presidential Records Act contemplates that presidents have these classified records. The Presidential Records Act does not differentiate between classified and unclassified, as David Ripken so well laid out in a Wall Street Journal piece about the Presidential Records Act. And also Congress gives the former president the ability to look at classified material, staff, SCIF, security clearances. And it's also, these are paper records under lock and key and Secret Service protection. This was not a home server that was hacked by foreign governments like Hillary's. These are actual paper records that President Trump declassified, which is his constitutional power under the Department of Navy versus Egan in 1988 confirmed that. And he also took his personal his copy and made it personal, as confirmed by when President Clinton had 8 years of audio tapes in his sock drawer. Tom Fitton and Judicial Watch sued in this 2012 case. The Obama judge said it is the president's sole determination whether these are presidential records or personal records. There is no case here whatsoever. Even if everything in this affidavit is true, even if even under the worst case scenario, if everything that in this if you unredact this and everything in there is true, there is no legal violation as a matter of law, because the president cannot violate the Espionage Act by declassifying records, and the president took a personal copy of these records so that he could not have stolen or hid or destroyed presidential records. So therefore, you can't obstruct investigations of these two non-crimes.
Well, the left has pretty routinely invented crimes that don't exist when it comes to Trump. So, for instance, when Trump had met with Russian officials at the White House, he had disclosed information reportedly to them that had previously been considered classified, but he did it at his own discretion. The left was accusing him of crimes for that, but that's not a crime. He's the president of the United States. He can declassify anything at whim, no?
Yeah, I mean, it's just, let's look at March of 2012, when President Obama's in office. This is 8 months before the presidential election in 2012. President Obama leans over to the president of Russia, one of Vladimir's puppet presidents, and President Obama says, essentially, tell Vladimir, I'm going to have more negotiating room after the presidential election in 8 months. That is highly classified information to tell our enemy. And if anyone other than the President of the United States or someone authorized by the President of the United States relayed that to our enemy like that, they would be in prison for espionage. But because President Obama was the president of the United States, he had the absolute, unquestionable constitutional power to do what he did because he is the commander-in-chief.
Now, I've noticed one of the other trend lines when it comes to handling Donald Trump is to, if they can't get him on any specific crime, they try to get him on obstructing the investigation of the crime that they can't get him on. So we saw that happen with the Mueller investigation, where the left had this fever dream that they were able to get Trump on obstruction of justice. Bill Barr took the energy out of that claim. But then we're seeing it happen again now, because in this affidavit, not only do they suggest the Espionage Act comes into play, but there is some suggestion here that Donald Trump may be obstructing the government's efforts to retrieve documents from Mar-a-Lago. What do you make of that?
Again, if you look at that, so Bill Barr had the Office of Legal Counsel do a deep dive into this issue related to the Mueller probe, and Democrats leaked this out, and they thought it was their smoking gun, and it actually completely undermined their obstruction case. If you look at the memo and read it on the obstruction section, and it is almost certainly unconstitutional to charge someone with obstruction for non-crimes, right? There have been a couple cases in our history where there's been obstruction for non-crimes, but it is like legally impossible to do, right? And it's nothing that would fit in this scenario. What I'm saying is there is no way you can charge a former president for obstruction related to how he classified, how he opposed an investigation into how he classified or declassified materials as the president of the United States, period, full stop. You cannot have an obstruction case for how a president responded to an investigation on presidential records that he made personal, because this 2012 case from the Clinton judge with the Obama judge with the Clinton software case made very clear that the president has the sole, is the language she used, the sole authority to determine whether something is presidential or personal. So you cannot have obstruction into these non-crimes. So if Trump dragged his feet and said, piss off, Attorney General Merrick Garland, I'm not cooperating with your illegal probe, that is not obstruction. These are non-crimes.
There was also some suggestion that if these secrets underneath of these redactions, if these redactions were revealed to the public, if the affidavit itself was fully revealed to the public, it could imperil witnesses or something, that like they may be put at risk. I can't even envision a scenario where that would be the case.
This is such nonsense. Now, normally these affidavits are not made public because you protect sources and methods. In this case, this is an unprecedented, unnecessary, and unlawful home raid ordered by President Biden himself when he waived executive privilege and set this in motion against his former and future political enemy. This is Watergate on steroids, right? And this Biden Justice Department is selectively leaking from this affidavit. We see these leaks constantly in Newsweek, the Washington Post, the New York Times, all of the mainstream liberal outlets they're leaking to them. They're not even pretending that they're not leaking to them. They leaked out that the number of records that are marked classified, the fact that Trump had the non-fact, the lie that Trump had nuclear documents, they're leaking out from this affidavit. They're actually even illegally leaking grand jury material. They illegally leaked to Newsweek that the grand jury found that President Trump had violated the crime, which is complete nonsense. So they're leaking from this affidavit, but then they want this biased judge to work with them to hide the information in this affidavit. What the excuse that they use with this biased judge to get this unprecedented, unnecessary, unlawful home raid on President Trump, now they want to hide that from the American people. Trump wants it out there. So what's the problem? Redact the names of their witnesses. What else do they need to redact? They redacted half of this affidavit, including almost everything of substance.
Okay. One other piece here. It seems like there are multiple touch points with the Biden White House that we now know that are public. So one of them is that Biden waived executive privilege for his predecessor. He decided, no, you're not entitled to executive privilege anymore. They're framing that as if he decided to recuse himself from that decision and let the archivist make it. But that's preposterous. So once you do that, that's clearly you waiving executive privilege from the White House. So he knows about it at that point. Additionally, the reason why the archives are under the opinion that they didn't get all of the documents that they wanted is because the White House had apparently provided an inventory of documents that they should expect to receive. So when they got those 15 boxes back voluntarily from Trump earlier this year, and it didn't include a number of documents that the Biden White House said you should be getting back, that's when this became a criminal pursuit. So clearly the Biden White House has been heavily involved here, no?
Absolutely. And for Merrick Garland to get out there and say that the White House was not involved was another lie out of Merrick Garland and the Biden Justice Department. He said he didn't authorize the raid. That's a lie. He said there were nuclear documents, or they leaked out that Trump had nuclear documents. That's a lie. Now they're lying about the fact that the Biden White House, including President Biden himself, were not involved with this. They were absolutely 100% involved with this, because the only person who can waive executive privilege for the former president is the current president. President Biden had to make that decision.
Yeah, sure enough. Mike Davis, thank you very much for your insight on all of this. Really appreciate your time today.
Thank you.
All right, it's 4:20.